Harvey Zarabi, attorney at law, having practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, employees' right to date coworkers in California. Generally, workers in California have the right to freedom of association, which means your boss or supervisor cannot regulate your personal relationships. California labor law protects your right to engage in whatever activities you would like while you are off the clock. As relationships are considered part of one's private life and outside of work, the fact that you are dating a coworker is not a legitimate reason to terminate your employment. Most workplaces understand the rules, and instead of banning workplace romances, they will ask employees to keep things professional and discreet. However, that doesn't mean you're off the hook if you're interested in dating coworkers. There are situations where a workplace relationship of an intimate nature may be grounds for termination, depending on whether the relationship has affected work performance or the other worker's rights to fair and equal treatment. A common example is when the relationship affects your job performance or that of your partner. If you used to perform your job at a certain level, but your relationship causes you to miss deadlines, make repeated mistakes, act unprofessionally, then there are issues that can cause you to be fired. Your employer would have to go through the protocols outlined in your contract or employee handbook, and they can fire you for poor job performance. Another cause for termination has to do with power dynamics, like those between employees and the supervisors. This can lead to favorism of the employees by the supervisor, which will most definitely create problems within the company. On the other hand, if the relationship takes a turn for the worse, the subordinate employee may file a claim for discrimination or sexual harassment against the supervisor. To prevent these headaches, employers generally have policies that prohibit supervisors from dating subordinates. These policies may appear to be a violation of workers' right to privacy, but in these situations, the conflict of interest it would cause in the workplace has a greater importance over an individual's privacy rights. If you believe that you were unjustly fired or face some form of retaliation for dating a coworker, you may be eligible for a wrongful termination and or retaliation claim. For you to totally understand your rights under the law, you should contact an attorney who can help you understand the extent of your protection. Remember, your rights as an employee are protected by law, and you have the means to take action if your employer fails to comply with the regulations. So stay informed, know your rights, and advocate for fair treatment in the workplace. If you have any questions on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.